Well, good morning, and thank you very much for joining us. I am Yori Folari. We're sort of picking up where we left off yesterday. We looked at two matters yesterday, but the second was the whole matter of the query from the Attorney General of the Federation to the Acting Chairman of the FCC, as well as Festus Keyamo, SAN. Festus Keyamo has been a lawyer of long standing with the EFCC, and so there was the whole content of the query. By now you probably are well versed in. It was about the Attorney General wanted to know and had asked the acting chairman to furnish him with the reasons for the latest charge against the chairman of the Code of Conduct Tribunal, Justice Danladi Umar, having been cleared by EFCC twice in the past. So the AGF sought to know why was there a need for him to be charged now. Among the things we looked at yesterday, and my guest this morning is another lawyer of long standing with the EFCC. Well, not long standing?
Not with EFCC.
Oh, you don't do any cases for them?
I'm not a lawyer to EFCC.
Wow. So you're missing out. That was just a joke. Malaki Ugumadu, who apart from being a lawyer, we also know him very well as the national president of the Committee for the Defense of Human Rights. Thanks as always, Malaki, for coming on.
A pleasure, sir.
Indeed. Now, so we were looking at a number of things were up in the air yesterday. One, why now is the AGF, making this inquiry? Two, some lawyers said there are channels anyway for lawyers. But I had said yesterday that I read in one of the reports that there was a PR firm reportedly that is working for, Justice Umar, as it might work for anybody, that had actually put this matter out in the public space. But nevertheless, it had been got. One paper said that as soon as that had been put out, it had gone across to the court and had gotten the actual documentation so that it can now say that, yep, it is exactly the way it went. Keyamo's matter, I imagine, will be a matter, not I imagine, for sure, was the Attorney General seeking to know the authority on which he brought up those charges. And it had been said earlier that, well, Mr. Magu, if it was you, explain why. So tell me, Malaki, you've heard the story as well. What do you think of the whole thing?
I think that's a very good question. What do you feel? I'm a bit hesitant to give a straightforward answer because there are so many sides to it, as I imagine, and as one who is watching from the sideline. The one is that under Section 150 of the Constitution, 1999, as amended, the Attorney General and Minister for Justice of the Federation is the chief law officer of this country. By Section 174, subsection 1 of the same Constitution, he reserves the right to initiate, take over, or discontinue any criminal, charge before any person in a court of law, except a general court-martial. There is a proviso to that.
And that includes specially set up tribunals?
Of course, any court of law, except court-martial.
Okay.
Special court-martial. Provided, of course, that he does that. In other words, exercises that discretion in the interest of justice. That's the only thing he may have to do to show that he has discharged his duty to the best of his conscience. Now, having those two cardinal constitutional provisions, you would see that he exercises enormous influence on justice delivery system in the country generally. So that one is known. The one that is not known is why this has become a public interrogation. That's the one I can't explain. And that is the hesitation.
Okay.
Essentially because...
You know, how about that point I made about it having been leaked by, you know, a communications firm?
Well, I wasn't privy to that, but
No.
I mean, if I also would want to move from that point, I would say, what are the strategies that the Ministry of Justice has designed to ensure that the business of dispensation of justice does not suffer so much by the kind of public interventions and interference as we have seen it, I mean, repeatedly over time, such that at the end of the day, you are almost unable to focus on the substance rather than the energy you dissipate pursuing public perceptions and public views about what ought to be a strict and precise judicial matter. Now, I have tried to lay this foundation to let you know that we understand the kind of influence, the kind of supervisory role, and the general control that the Attorney General has with respect to, you know, prosecution of cases in court, particularly regarding federal offenses. We also are disturbed as to the lack and total absence of cohesion and coordination of inter-government agencies, particularly when they are supposed to be effective collaboration enough to guarantee the success of one of the cardinal objectives of not just this government, but in the interest of the country, which is the fight against corruption. How does it work? When you witness, and when I say when you witness, I'm talking about when the public is treated with this degree of incoherence, with this degree of agencies working at cross purposes, as it now seems, you won't have any difficulty in coming to the conclusion that it is not all well in the engine room, let alone the delivery of that crucial assignment. This is my concern. And I had imagined that there had been a series of incidences in the past, very recent past, for which reason the government itself, albeit these institutions and offices directly involved, ought to take corrections. We're here when government actors, state actors were talking at cross purposes regarding a cardinal plank of this administration. We have seen them work at cross purposes, challenge themselves, issue contradictory statements and directives, and we have seen quarrels, most of which unnecessary and avoidable, already sending signals that, wait a minute, whereas the Pope is busy sermonizing and pontificating, the laity are confused. The congregation is disorientated.
And you know,
the big problem, Ms. Yori, please pardon me, is that this fight against corruption, which is at the heart of this discourse, is not the business of the Attorney General or that of Magu or any other special lawyer who has been conscripted to assist. It is the business of the Nigerian people and can only succeed when indeed they own up to that. So what the managers of this process needed to ensure and guarantee is that these people whose business it is, the populace, the Nigerian people, whose responsibility it is to own this fight and bring it to fruition, What they needed to do is to be able to ensure the certainty of the process, the viability of the activities, and then the need for their buy-in. You can't achieve that when we barely peep through the window and we already concluded that the center cannot hold in that room, let alone finding ourselves in that engine room. So this is my concern.
Because we know so little, as you have also indicated, about what exactly is going on, people yesterday when we had this conversation were saying that, well, you've got to read between the lines, which is always a problem. Look, why can't you be clear if you're going to be sincere? When we get to the level of reading between the lines, that's a totally different story. Now, we said, okay, let's look at it in the very, very basic kind of a way. You don't need to be a lawyer to understand that, look, a person that is looking at it from EFCC's point of view, a person might indeed have been discharged, although I'm not sure that Fasi Yusuf was here yesterday. He was very unhappy with that word. That is not a matter of discharged and acquitted, but whatever. There is no case here. You did that the first time. Then you did it a second time. Now, common wisdom will say that having been cleared twice, if you actually go and commit an actual offense next, then the police or EFCC or any other proper authority is at liberty to approach you and do the necessaries. We said that's one side. We wonder what EFCC's response will be. On the other hand, we were confused that the EFCC, I mean, the Attorney General's office, I would imagine you explained how he supervises. He's the chief legal officer, supervises just about every other official lawyer, can just ask for this information. So it would look as if this whole thing is becoming some sort of a, if not parable, at least saying about, it's a commentary, as you have just so appropriately said, on the way we're going about this fight against corruption. How are the people going to buy into it if they are confused half of the time?
One of the reasons why the Committee for the Defense of Human Rights proceeded against Andoka, the former Attorney General and Minister of Justice, was because we were able to collate and document and profiled that within his tenure, up until the time we moved against him, he had withdrawn more criminal cases than he instituted. Section 174, subsection 1 of the 1999 Constitution, as I referred earlier, starts with the word can institute. It's describing the powers of the Attorney General. Before he talks about withdraw, he can institute, can take over, and can withdraw, which is what we call enter nolli prosequi. But we were able to document by far more withdrawal cases in very brazen criminal charges and allegations. You see, granted, and I'm speaking as a lawyer, granted that the exercise of that discretion is largely predicated on the cold facts as to the body of evidence that is assembled for what? To be able to achieve conviction if you are exploring the possibility of prosecution. That is what influences that discretion.
I see.
And to that extent, he is vested with that power to exercise that discretion. We appreciate that. But you know, our people say the man who cries also sees, even if he's weeping, and you know, we are all here together. And the question has become rampant. First, what is the level of coordination in this ministry? How come we hear discordant voices? The Office of the Attorney General would want to move. Other law enforcement agencies under it will refuse, or vice versa, which is usually the case. They want to move, they say no. You are aware that a letter had emanated from the same Office of the Attorney General to the President, urging it to discontinue the case against Adoke and who again? Now, if you take a very recent introspection into that Adoke case, Adoka case, you will find that only recently the same Office of the Attorney General insisted that it must proceed with the trial of Adoke. When Adoke went to court challenging the charges against him from diaspora or wherever he is. Now, I've just informed you that the same office that I earlier had taken that position is now the protagonist, pushing the position that there are no sufficient what? Evidence. Now, if that can happen from the office of the Chief Law Officer of the country, pursuant to Section 150, how much more an investigating agency of the same government? The point is simple, and this is peculiar to criminal administration of criminal justice. If as at today, the allegation against you is such that the investigating authority has very little or insufficient body of evidence to nail you. Again, you know, I almost insist, always insist, that the standard of proof is beyond reasonable doubt. So it's immaterial whether you have very patry, insufficient, enough to secure conviction. If that is the position as at today, and by tomorrow you stumble into the real trump card, you assess the real evidence that you need to secure conviction. Whatever you said in the past must have to give way.
Okay.
Must certainly have to give way if you are interested in obtaining justice. And let's face it, justice is not a one-way traffic. Justice, as we know, practicing law, is a three-way traffic. Justice for the state, which is this Nigerian state, bleeding for years now, so much so that even Babangida had once said that he really, truly doesn't understand how Nigeria can still survive. That's President Babangida. The state, justice to the state, which is a victim of all of these transgressions, leading to her inability to live up to Section 15, subsection 2B, that says that the primary purpose, the threshold purpose of governance is to secure lives and property. I hope you are aware that we are already in another round of about 90 female students in Yobe, as I understand it, have been adopted, or at least missing as of today. That same state that cannot provide health facilities, for which reason all the actors of states, including those that have cough, malaria, get out of this country in search of medical attention. That same state that relegates the primary conditions of humanity to the background Because as they claim, they cannot afford it because there are no resources to do that. The same state, I can go on and on.
Now has this challenge on its hand. What?
That same justice, that same notion of justice, is not only to that state, it is to the victim.
I hear you. I hear you.
Of that malfeasance or transgression. It is.
And all these constituencies are suffering as a result of a lack of, shall we say, due process and the way things should be. Now, what is your understanding as to what is going to happen? Because Justice Danladi Umar, but he still has a judgment to deliver, in his Code of Conduct Tribunal, I believe. They were saying something about the Saraki affair.
Okay.
That a judgment is still expected at a future date.
Yes.
So the confusion that I, as an individual, had yesterday was that if the Attorney General is insinuating that everything isn't kosher with the way things are, that's why it's asking for this clarification. And just staying with that for the moment, but not really commenting on it, why would EFCC be doing anything to prevent a judgment that would be the culmination of all the work that it has done and all of that? Because the point was made here that, theoretically speaking, just for explanation, if Justice Umar were indeed, to not get the better of the charges against him, then he can't sit in judgment on anything again.
That's the Judex generally is a very special institution in any country. Any country that parades itself as practicing constitutional democracy. It's not just special, it's sensitive. And, expectedly, the level of integrity that is needed to be operational in the circle of judicial officers is even higher than what you expect from other institutions of state.
Because justice is about life and death.
Correct.
It's a life and death matter.
Correct. And it's not even far-fetched. Only recently, when the same issue played out with some judges, the argument became so intense that even the National Judicial Council, that was initially opposed to taking steps as to relieve temporarily the affected judges, came out and suspended those judges from sitting pending the determination of those investigations.
Yes.
I leave the rest of the story for another day. So I concede that it is a very, very special office, very sensitive. Pardon me for going back to the Constitution.
Okay, but I'm very sorry about this. Can I just bring on Lawrence, who has called in and wants to join the conversation? Lawrence in Ojodu, good morning. Okay, no wonder. He was having difficulties connecting.
Correct.
You wanted to bring back
So
the
I go back to the Constitution just so to underscore or emphasize the point that you are making as to how could he possibly continue to be there if these allegations. Section 155 of the same Constitution, subsection 2, which talks about removal of members of the statutory bodies created under section 153, those special bodies, including the CCB, Code of Conduct Bureau, is to the effect that if such a person is involved or indicted with any form of allegation which would have been sufficient to disqualify him from being appointed in the first place, such a person will be removed. So I understand where all of this is coming from.
So where does that
But
leave
there is no...
EFCC and its work? And you understand what I'm saying? So I didn't understand when I referred to my own personal confusion. Maybe it's largely because one is not learned in any way, shape, or form. That if EFCC is chasing him, although that chasing him is not quite the word, investigating him, its own work that it wants a resolution to, it's hardly going to come about. But in any case, let's leave the point for now, because I just wanted to bring up that if anybody's seen one of the papers, an SAN, Mike Zekome, OFR, SAN, he has a column, Hard Facts, in one of the papers. And he actually has, he did something today, the caption of which is, "An innocent victim of strong principles," referring to Justice Danladi Umar. So even before we understand exactly what is going on, we don't know whether the queries have been answered within the 48 hours suggested when it was issued, which expired yesterday, so that today, if everything went according to plan, both Mr. Keyamo, if he went that way, and for sure Mr. Magu, must have the answers in the EFCC's, in the Attorney General's office right now. So I don't know, give me your take that while we're waiting to hear of some development on the case, Ozekome has actually jumped in and said that, look, this man is an innocent victim of strong principles. Innocent victim, of course, has its connotations. When you make a statement and you choose those particular words, he's weighed in, and he is clearly weighing in on one side. Your comments?
I am not privy to what my learned senior colleague has committed to writing, but I've seen it.
Yes.
Not having read it.
Yes.
I may not be able to fully characterize
okay.
what he's saying.
Before you continue, let me bring in Reverend Dominic, who also, you know, we were together yesterday. He's come again today. You're very welcome, Reverend Dominic.
Good morning, Yuri.
Good morning, Dominic.
Good morning, Mr. Malaki.
Reverend, good morning.
Yuri, let me make my position clear yesterday. I wish you can permit me.
Okay, go ahead, please.
What I was saying yesterday is what Barrister Macaulay is saying now. That I didn't say...
Not Macaulay, Malaki.
Malaki, sorry. I didn't say that the present Attorney General, the Magu, DSS Chairman, all of them there are guilty on any offense. But they are guilty of not coordinating government business. The problem, let me give you an example. The problem Magu has today with the Senate is not from the Senate to be fed to them. It's from the same executive who gave two different reports to the Senate. And this report came from one office. What I'm saying yesterday is that Mr. President Buhari is like a supervisor in a company. He supervises all his own staff. And when his staff is not doing well, he has the privilege and the right to say, please, you can go. Let me find men and women who can give me direction to governance. But these people are not giving it. We saw the fight the other day in Abuja, where EFCC and DSS were fighting openly. We saw in the Senate sitting where EFCC were calling with DSS. We saw in the Senate where DSS was trying to tell us the trouble they are having, that is because of EFCC and all the rest of it. You saw the pension crime, how we manage it. This government have become discordant and fighting themselves. I mean the executives. Executives are supposed to work like a team. But they're not working like a team. We who are spectators are confused. That's what I say, that Mr. President, if he's ready to sanitize Nigeria and fight corruption, must find men and women who will speak with one voice. That was my own position yesterday.
All right, then. Thank you very much for calling in.
You saw the pension crime, how we manage it. This government have become discordant and fighting themselves. I mean the executives. Executives are supposed to work like a team. But they're not working like a team. We who are spectators are confused. That's what I say, that Mr. President, if he's ready to sanitize Nigeria and fight corruption, must find men and women who will speak with one voice. That was my own position yesterday.
All right, then. Thank you very much for calling in, Reverend Dominic. And at this point, we'll go on a quick break. Please don't go anywhere. We're going to come right back, continue, and we'll be taking your calls. So welcome back. Barrister Malaki Ugumadu has been joined by Comrade Larry Suraj, because that's how I heard, you know, Barrister Malaki hail him. I was going to say Mr., but since I heard Comrade, I'm going with Comrade.
You're very correct.
Comrade Larry Suraj, Chairman, Civil Society Network Against Corruption. Thank you, Larry, for coming on the program.
Always my pleasure. Thank you for having me.
There's some catching up. There's some catching up that you have to do, because we've been at this for a while. But then again, it's one of those endless subjects. I think what people feel the most who are not insiders is a sense of confusion. Why, Reverend Dominic has just finished saying, are the different aspects of government seemingly fighting against themselves? Why is there no cohesion? Why is everybody not working as one team? The DSS and the other one, what's the second one? They are constantly, well, let me not say constantly, they have given conflicting reports on the gentleman that we're talking about, EFCC, when the special security things were needed. Now, I mentioned that this morning, in one of the papers, Barrister Ugumadu's learned friend, Michael Zekome, OFR-SAN, he put an article, not an article, it's a column, he referred to Danladi Umar as an innocent victim of strong principles. Let me just read one, a highlight, because the paper itself just took a few words and highlighted that, and it's telling. Inter alia, it says, the anti-graft agencies are political tools. The anti-graft agencies are political tools in the hands of government in power to hunt down, browbeat, intimidate, coerce, harass, and force allegiance from opposition dissenters, critics of government, and non-conformists. Well, just a few words that I just took out of it sort of gives you an indication, and with the caption of an innocent victim of strong principles as a caption, you have something of an idea pending when you read it fully. Give me your take on all of this, because that's the question that Malaki started out with. What's going on? Do you know? I would have loved to be able to hear a few words from Festus Keyamo, but very, very difficult. Lawyers are always busy. What do you think?
Yeah, I think we actually are the ones that are really not in tune with development, and I think the Nigerian populace, generally most of us. The fact is simply that it is inevitable. The conflict and contradiction must play itself out. And one thing that is actually...
Why must there be conflict and contradiction in a Buhari regime that came with a single vision?
No, let's not make a mistake. When we say, you say Buhari regime, that also signifies an individual. They're still going to, which is going to work with a political party. It's going to work with some characters, with individuals, and it's going to operate within our known political elites. So, meaning that for you to change that kind of system, there must be a whole lot of contradictions and conflicts that must play out. Allegiances, your parties will nominate even ministers and the rest of them, board members. Political godfathers will do the same. Sponsors of political party will do the same. So you have a basket of mixed fruits that are going to. But one thing that we must also appreciate is basically, like you said, there's been the conflict between the EFCC and the NIA. There's been the conflict between the EFCC and the DSS. There's been the conflict between the EFCC and Office of the Attorney General. So now you would ask yourself, there must be a common denominator within all of them. So which one is on the side of the people or on the side of the principle? If EFCC is doing something wrong, then it means probably the three of them will be doing something right. But if EFCC is doing something right, the three of them must be doing something wrong. Which one of them has changed over the period of time? And I can tell you, you've not seen significant change in DSS. There's been no significant change in NIA. There's been no significant change in the Office of the Attorney General. So EFCC, which is making the significant change, and you can see with the records, in terms of the recovery that the Commission is making, in terms of the assets that are forfeited, in terms of even the prosecution, you can't hold it responsible for outcomes of prosecution, there are several factors that are beyond the institution in terms of securing conviction. So you can't say how many convictions, so except you don't understand the dynamics of how the administration of criminal justice operates. So it means the EFCC is doing so. So now let's go to this one. And I couldn't help but giggle when you read what Ozekome said. Ozekome works, Mr. Ozekome, SAN, works with
OFR,
well, I mean, I can choose to ignore those ones. So he works with the Senate president, and he's worked with quite a number of those who are accused of corruption. And if the Senate president at one time challenged the credibility of Mr. Umar, that is the Code of Conduct Tribunal chairman.
Justice Umar.
No, it's not justice, it's Mr.
I see.
The Code of Conduct is in trying his matter up to the Supreme Court. I wonder how an SAN would come and call such a character a person of impeccable or impeachable character and standing. That is number one. Number two, going by the letter, it's very clear and simple. The so-called exoneration of Mr. Umar by the EFCC actually happened even before Magu. And there's nothing that says, on the basis of new facts,
that's the point,
coming before the commission, that they can charge him. And you will see the contradiction, not even in the EFCC or in the matter, but even in the Attorney General. In the Attorney General, in the case of the Malabu, you saw the letter that came out where the Attorney General said there's a need for further evidence to secure conviction. And he was cautioning the commission from going ahead without further evidence. So it means that it requires such number of evidence and weighty evidence for you to go ahead with prosecution. I mean, now saying, why should they go ahead? You know, when, it doesn't actually add up. It doesn't make sense. It's an agency that is rested with the power of the investigation.
And that's what you just said, it doesn't make sense. That's not something that the people require. Everything that is being done about corruption, the fight against corruption, needs to make sense.
No, it won't make sense when you still have some of these elements there. And until the people, like he said, it is not their fight, it is our fight. We must be able to make the sense out of them. We must be able to make the demands. We need to help not even only the EFCC, not even only Buhari. We need to help the country by putting the issues appropriately and not being deceived. And you would ask yourself, the letter that was written by the Attorney General that was used in court by Adoke's lawyer was written to the president. It was a memo from the office of the AG to the president. How did that get to the public domain? How did it get to the hands of the lawyers to Adoke to the extent that it was now used in court against the EFCC by lawyers to Adoke? So you ask yourself, so you would understand that quite a number of things will really not make sense until we are able to force sense out of them.
You know, you gentlemen, but both of you at different times, I don't think you were in the House when Malaki had said that it's the people's business and the people need to take hold of their business.
Precisely.
You have said exactly the same thing. But how realistic is that?
Believe it's my comrade.
How realistic really is that expectation that people in Nigeria, because you both, especially you've just said, there's a particular Nigerian milieu within which anybody has to work. So how realistic is this whole matter about there being a people uprising? In Burkina Faso, Thomas Sankara, after he was murdered, Kampore took over and reigned for 27 years before this uprising that you're talking about. It took 27 years coming. But when it came, it came.
Right.
Because we are how we are, I don't know if it's an African thing or not, I'm just fearful that all this take possession. Obasanjo also said it, that people in his letter, in his now famous letter, take possession.
So is it famous or infamous letter?
I think Mr. George is on the line. Mr. George in Ikeja, good morning, sir.
Good morning, Uncle Yori.
Thank you for calling in.
Uncle Yori, yesterday, I think I was telling you that the position of the Attorney General will soon be, that the truth of the matter will soon come out. I don't know if you have heard that the presidency has already directed him to continue the prosecution of the people he had asked EFCC to hands off their cases.
There you go.
Maybe it has not reached you. Before the end of the day, you'll probably get the details.
I shouldn't even be as bad as
When
that,
you-
Mr. George. Now, why are you rubbing it in? but please continue.
Uncle Yori, when you see a suspect on trial sympathizing openly with the plight or so-called plight of his judge, something to tell you that something fishy is